Good afternoon, everyone. Good evening, whatever time of the day it is where you are. I hope you're all doing well. I can see that people are starting to come in quickly. If you have attended one of our webinars before, you know that I don't like to waste time with chit chat. I like to get straight to the good stuff. If it is your first time, however, I will say welcome. Thank you for joining us, and I hope you find it informative and worth your time. So I'm just going to begin with a very quick introduction of the ICCP before I hand it over to today's speaker, Amit Kathpalia. Okay, so who are we at the ICCP and what do we do? Well, the Institute of Construction Claims Practitioners is a professional members organization that recognizes those with the skills, qualifications, and expertise in the professional management of construction claims. So we have three primary objectives, which are to establish international professional standards for claims, to give recognition to those who have gained the knowledge and skills to appropriately manage claims, and to help and educate those who would like to learn. And why is there the need for the ICCP when there are so many professional organizations serving the construction industry? Well, quite simply, the construction claims aspect has become a key part of the construction industry around the world. And the professionals who work in claims have come from a variety of backgrounds, from engineering, quantity surveying, project management, legal, and somewhere along the way, they have gained those skills, or they would like to. And the people who have gained those skills deserve recognition, and the people who would like to gain those skills need a place to come. And that's us. Until the ICCP was established, there was no institute that specifically recognized those who have the specialist knowledge, experience, and skills to be able to manage, prepare, and respond to claims to the highest levels of professionalism. Okay, I'll briefly introduce that we have a steering committee, our executive officer, an elected president, 3 elected fellows, and Nina is the general manager. She's currently on maternity leave, and I'm filling in for her. In terms of membership, we have 3 regular levels of individual membership that each have their own criteria. We also have student and graduate membership for those who are just finishing their initial qualifications. We also have corporate membership for companies that have departments that specialize in claims, or obviously entire consultancies that specialize in claims. And what's in it for the members? We have a private area of our website for members, which has a collection of articles, white papers, research, etc., collected in one place. We also have information about further education and training that's not provided by us, but just the information is collected in one place. We also have a bookshop, which again does not sell books, but we have reviews of the latest industry releases. We have a library of practical templates, which help our members save time with their claims and also ensure that they are completed to the highest standard. We have regular CPD opportunities like this one. So all members who attend this session today will receive a CPD certificate. The session is free for non-members, but the certificate is a benefit of membership. We also have the ICCP Academy, which is for members only, and it's a more technical CPD sessions that we provide several times throughout the year. We offer discounts on books and training through Wiley Blackwell and Routledge Publishing, as well as our training partner, Claims Class. We have a monthly newsletter to keep members up to date on the latest happenings in the industry. We offer industry exposure in the form of a public listing of members, as well as the standard benefits of membership certificates and logos. And we have a private LinkedIn group where members can discuss their contracts and claims questions in a confidential setting. We finally have the optional benefit of the Register of Claims Practitioners, which is for members who would like to have their own webpage offering their consultancy services. Okay, I know that that was quite a quick little tour around the ICCP. So if you requested additional information when you signed up for today's session, I will be sending you an email. If you did not request additional information, but I have piqued your interest, please have a look at our website, instituteccp.com, or you can email me, jennifer.smith@instituteccp.com. Okay, and with that, I'm going to hand it over to Amit, who is a fellow of the ICCP, as well as the author of the recently published bestseller, Practical Construction Contract Issues Which Are Not Commonly Understood. And that is based on his many years of experience. He is coming from 33 years in the public construction sector, 5 years in corporate, and 6 years in training. So I think you will be in very good hands today. Thank you for joining us, Amit.
Thank you, Jennifer. Thank you so much. Pleasure to be here today. Let me just share the screen. Okay, just give me a minute. Sure. Thank you, Jennifer, and thanks to ICCP for this opportunity. I hope I'm audible. Jennifer, am I audible?
I can hear you just fine.
Okay, great.
If anyone cannot hear, please put it in the Q&A box.
Okay, so today in the next 45 minutes or so, I'll just discuss about what is happening in India. Okay, great. I think that's confirmation. So I'll just discuss about what is happening in India, and construction dispute is a huge gamut of what's happening in India. So we'll just see how we are navigating this maze of construction disputes that are happening in India. So first, let me just give you a little introduction to the infrastructure aspects of India. Yeah. Okay. We have a national infrastructure pipeline which was announced by Indian government in 2019. The budgeted expenditure, and which is going on like this for 5 years, is $1.6 trillion. Now, to the best of my knowledge and research, this is more than the entire budget of Europe and US combined in these 5 years, what they're spending on infrastructure. The next 5 years is going to be in the range of $2 to $2.5 trillion. And while financing is a little bit of issue, but not the major issue. Finances are available in India and things are going, the projects are going on. They are not lacking or being stalled because of lack of finances. That's not the issue. So what is the issue? Let's see something like this. Now, World Bank ranking of India. In the last 10 years, India has improved its rankings in almost every sphere, in some cases considerably, like ease of doing business, 142 to 63. Getting construction permits, which was traditionally a very difficult thing in India, gone down to 20. But one thing where India has not improved its ranking even one bit and is in the lowest 5 percentile of the world is enforcing contracts. This includes dispute management. We stand at 160. We were at 163 10 years back. We are still at 163. So why is that happening? And infrastructure disputes, construction disputes form a major part of this. So overall, we have our judicial system, as every Indian who's attending this session would know, is clogged with huge cases. We have about 50 million pending cases of all types. And we have a think tank, Niti Aayog, which is Niti stands for National Institute for Transforming India. Earlier, it was called Planning Commission of India, who have given their study that in India, it takes an average 14-20 days for dispute resolution. And it takes even 2,500 days to implement an arbitration award. Average settlement of a construction dispute in India takes about 7 to 8 years. And today, if no additional court case comes to Indian courts, it will still take more than 300 years to resolve all these cases at the current disposal rates. So there are various issues: infrastructure, number of judges. India has a huge lack of judges. We have 20 judges per million of population, as compared to US 150 and Europe 200 and China 300. So there are problems in the legal system, huge problems. Let's take another data which comes from Ministry, and MOSPI stands for Ministry of Statistics and Planning Information, which carries out compiles various statistics. So if you see this MOSPI data, this gives you this MOSPI compiles uh, information about projects, all projects which are uh, 1.5, more than 1.5 Indian rupees. That works out to about 18 million US dollars. So 1.5 billion US Indian rupees, which in India we call 150 crores. So it gives you a cost overrun in the range of about 12 to 23%, and a time overrun averaging about 40 to 50 months for projects, for bigger level projects. But there is something missing in this data. This data also gives you reasons for delay, which is ranging from land acquisition, and forest clearance is a very major issue of delay in India. Other than that, of course, changes in scope, tendering issues, geotechnical surprises, which happen everywhere. But this data does not tell you one thing, which is cost of disputes. That is not added in the data. Claims, interest, project, the cost overrun is added, but not the cost of disputes. That happens because a dispute generally takes 7 to 8 years to get resolved. And you come to know the real cost of disputes after a period of 7 to 8 years. And then there is a little cross financial accounting goes from the suspense account of Indian government to the consolidated fund of India. It doesn't get accounted into the project cost. So I did a little research in the course of my doctorate, which I'm doing now, where I took some railway awards, which were in open domain, railway arbitration awards. And I found that about 43% of the original contract award had to be paid by railways, more than that, in fact, in the form of claims and interest. And the interest component formed a major portion of these awards. And each of these awards, the average time for implementation of this arbitral award took about 7 to 8 years, because one had to go to a court and then get the implementation order. So this was the value. The value of the award was, as we call in India, 1700 crore, which works out to about 17 billion Indian rupees. That's about 200 million US dollars. And you will notice that about 10 billion out of 17 billion was the cost of disputes. And I'm not counting in this the litigation cost, cost of arbitrator, cost of lawyers, and so on. So a huge cost of disputes, almost 60% of the project cost came as cost of claims, interest, and disputes. Now, I'm sure many of you would be familiar with Arcadis Construction Dispute Report. The Arcadis report, which is published every year, does not have statistics for India and China. It doesn't give statistics for that. But just to compare, 2022, the latest report gave an average dispute length of 15.4 months. And the number one reason for dispute as poorly drafted or incomplete or unsubstantiated claims. Now, if you compare this with just one agency of India, National Highway Authority of India, today NHAI of India is facing disputes claims in arbitration worth US $12 billion. The average length of resolving a dispute is 8 years. And it is estimated that the payment of construction companies held up in only Indian public sector infrastructure projects is to the range of 36 billion US dollars. I am focusing more on public sector because almost 70% of Indian construction budget and disputes pertain to 70 to 80% pertain to public sector. So that's a huge amount, both of held up money and the cost of claims and the interest component, and plus the legal cost, which doesn't get reflected anywhere in the project. So what are we doing? This is my own research in the course of doctoral research, which I'm doing. This is a no-brainer. I'm sure all of you would have faced this. So my research is basically solutions on delayed payment in Indian construction industry. So these, of course, I found that number one delay is in final bill, final account, followed by variations, then retention money, then interim, then advance. So this is a no-brainer. I'm sure all over the world it's almost like this. And then I put in 35 causes which had to be rated almost by 2,000 participants, equally comprising of contractors, employers, public sector employers, consultant, and some academicians. And you will notice the first 5 causes were contractually related. So the delayed payments, for out of these 4 causes shown in red, were actually imbalance and skewed contracts. So no lack of clear provision in the Indian Contract Act 1872. We have a Contract Act in India, though we follow a British common law. Our contract law is totally based on British contract law, but we do have a Contract Act, which was codified by British in 1872, but it's not a civil code. It's a statute, which, as all statutes, give you a guideline. So lack of unambiguous provision in common law and Indian Contract Act. So for example, I can, in India, I can make a contract which gives you an interim payment term of 120 days or even 5 months, and I've done it for a private developer. And there is no embargo on that. Unlike, say, construction law of UK, IGCRA would not allow it, or a SOP Act of Singapore would not allow an interim payment term of 120 days. Imbalanced contract conditions skewed in favor of payer happens all over the world generally, but more here. Lack of adequate provision in contract to ensure timely payments and penalties for delayed payment. So I can write in my contract no interest for delayed payment, and that's legal. Poor understanding and knowledge, so that's a capacity development. And finally, lack of adequate provision in contract on the pricing methodology and payment of variation. So these came out as the top 5 causes of payment delays in India. And you will notice what we generally think as causes: industry culture, poor maintenance of record, lack of trust, corruption, mistake in invoices, change in laws, or change in markets, industry market, too much bureaucracy, overall market fluctuations. These all came at the last. So the basic causes was skewed contract and capacity. It was not fluctuations in market, it was not bankruptcy, it was not bureaucracy, and so on. So what is India doing about it? That's a very interesting experience about what India is doing about it. A very, very interesting experiment. As we have seen, litigation is not an option. Courts are choked. So we have to think of ADR. Now in ADR, it is the ones above the dotted line, which actually everybody would want to do. Arbitration is the last resort. Everybody knows expensive and not really a solution. So let's see how India proceeded in finding solutions. We are still experimenting, still trying to find, and we still haven't found a solution. So the first solution that India tried to do was go in for arbitration. We had an Arbitration Act of 1940, but that was very rudimentary, and that led to, and that did not stop interference by the courts. So there was huge judicial interference, including re-looking at merits of the arbitration award. So the 1996 Act, which came in the same year, I think it may have been motivated by what happened in UK, because the Arbitration Act in Britain also came in 1996, the new one. So it dealt with domestic, international, all kinds of arbitration, gave party autonomy, very similar to UK Arbitration Act. And basic thing it was meant to have minimum interference by courts. So now courts could only interfere on grounds of public policy, which was defined in a particular way. Public policy meant fraud, corruption, basic notions of morality, in contravention to fundamental policy, or blatant illegality, incapacity, or the arbitration agreement itself was invalid, sometimes for procedural flaws, and dispute was not falling within the scope of arbitration. So that was the only reason. And courts could not obviously relook at the merit of the awards. They could only dismiss the award, or they could dismiss portions of the award. As they say, sever the award, some portions to be implemented, some portions to be, but they could not modify an award. So that's in consonance with whatever is happening in arbitration in all over the world. But was it successful? That is what we have to have a look. So this was one of the decisions given by Supreme Court, that even with the same evidence, if the court would have arrived at a different decision, It will not still interfere with the arbitral award as long as the arbitrator gave a reasoned award. So that's in consonance with the best practices of arbitration. It also gave some time limits, procedures, interim relief, injunctions, etc., and laid down the time frame for completing arbitration, 12 months, extendable up to 6 months. But it could be extended further also with consent of both parties. Then there came an amendment which laid down fees of the arbitrator. And finally, a new amendment which tried to move towards institutional arbitration, but that still hasn't come in India. So almost 70 to 80% cases in India are ad hoc arbitration. They are not institutional arbitration. We do have institutes, but institutional arbitration is still not mandated because the apex agency, the Arbitral Institute of India, the apex agency which is going to recognize these institutes and grade these institutes, hasn't come about. So therefore, people prefer to go in for ad hoc arbitration. Now, why did this arbitration succeed? One of the reasons was that almost 90% of arbitral award got challenged in court. Now, although the courts may not interfere, and there was very limited scope of interference, but the very fact that you had to go to court to enforce an arbitral award meant a delay of 5 to 6 years because of the clogging of our courts. Then there was a little problem, especially in construction field, where arbitrators were not specifically trained. So we had huge training of arbitrators. We have many institutes who train arbitration, national law schools, various things. But there is no specific discipline in any university or any law school anywhere on construction arbitration per se. Very high fees of arbitrators, that's a problem all over the world. Then Indian contracts traditionally also had something called accepted matter, which were beyond the purview of arbitration. So you will find in Indian public sector contracts a lot of clauses which says quantum of LD to be decided by the engineer, and this will be final and binding. It will not be purview to arbitration. So therefore, this led to a very funny situation where for some claims, you had to file a legal suit, and for some claim, you had to go for arbitration. So accepted matter, you had to take the legal recourse, and remaining, you had to go to arbitration. And similarly, because of lack of training, lack of specialization of construction arbitration, you landed up in some arbitral decisions which were upheld by courts also, but which were not really the best of judgments. So, for example, concurrent delay in India invariably is decided by arbitrals based on an apportionment method and a broad way, 50-50, 60-40. Now, that's not the best method. We all know abroad it was decided in Shefford in court case, which came in some criticism. And that's not the method really favored in UK and other countries. But in India, almost everybody decides like this 50-50 without even doing a delay analysis for the simple reason that it's easy. So that's not the best way of doing. This is basically capacity building. So these were the issues which happened with arbitration. One was lack of training specifically on construction arbitration. Now you have institutes coming up, private institutes who are trying to fill this void. Many contracts allowed arbitration only after practical completion. Then there was some suspect of bias. So people suspected arbitrators to be biased in favor. So let's say you had an arbitrator panel. One party selects one arbitrator, the second party selects second arbitrator, and then both select the third one. So there was a suspect that the arbitrators were in favor of the party who selected them, and everything then depended on the third arbitrator. Then often there was a problem that there was a accusation that hearings were being prolonged because fees of the arbitrator is on per hearing basis. So a hearing some arbitration which can be finished in 6 months were being prolonged to 1 year or more. Payment is on basis of claims. So arbitrate, though there is an upper limit, but payment is 0.5% of the disputed claims. So if claims are inflated, which invariably they are, it led to huge fees of arbitrators. So the net result was that arbitration, which was the first ADR method which came into India, while somewhat lessening the burden of the court, didn't achieve what it was meant to do, which was basically fast dispute resolution, give better quality awards, and gain trust of the parties. So all these things didn't happen, especially in the construction industry. So next experiment, next solution that India tried was DRB during the currency of the contract. Now, this also more or less failed for the simple reason that two reasons: poor implementation, basically. The DRB members who were put were primarily ex-employees of the government departments, and people didn't have much faith in their partiality. Standing DABs like FIDIC were rarely instituted. I have rarely seen a standing DAB in India. They are regarded as infructuous expenditure. So DRB, DAB were both ad hoc. And so this on more or less, there was no interim binding nature of a DRB. So it was almost like a mediation, and you could, the party could just simply refuse to comply. There was no time bar also. So these failed. DRB also more or less failed. The next solution that was tried in India was commercial court. So there was a Commercial Court Act 2015 which came into being, which designated specific portions of High Court and District Court for only commercial disputes. And this was put in all district level and all high courts. So these were called commercial courts, and they were meant for all kinds of, but only commercial disputes above a certain value. Now, this also somehow failed for the simple reason that it was not implemented well, though it was quite okay, but it was not successful because firstly, you didn't have the judicial capacity. So the same judge in the High Court was in charge of commercial court, and he was handling other cases also. As we saw, the judges to population ratio in India is very low, 20:1 million. So as a result, there was a very low disposal of rates of cases and lack of separate infrastructure. So primarily, this failed due to, I would say, judicial capacity and infrastructure. The intent behind it was very good, but it somehow did not get implemented because of judicial capacity and the infrastructure. Some innovative measures were tried by Indian government, which have now more or less norm. For example, a party can take 75% of arbitration award immediately on the minute award is announced on submission of an equal amount of bank guarantee bond. But this also didn't find favor because in India, bank guarantee bonds carry a reasonable amount of interest, maybe as high as 1.5%. And therefore, people were not too willing to keep paying this interest and keep their BGBs deposited while the case was going on in court for 7 years, 8 years. So this is somewhat was not very successful. Then came a very innovative measure in 2017 for the first time, starting with National Highway Authority, Ministry of Roads Transport. And now it is there with ports, with the shipping ministry and with power ministry. And this was setting up of conciliation and settlement committee. So this was set up at the apex ministry level, comprised of only 3 to 5 people of very, very high integrity at very senior level, not judges. You may have a judge, but generally this comprised of ex-secretary of the ministry, various other technocrat and various other things, but very high integrity and competence. And it was a very unique model. It was like it was a conciliation only, time-bound, 6 months, voluntary, very informal. The conciliators were based on a success fee model. Now, generally, if you go in for normal conciliation and mediation, success fee model is not the preferred model for mediation. So conciliation, here it was a success fee model. So there was no incentive to prolong the dispute. 50% cost sharing of conciliators. And if settlement is achieved, the ministry gave an assurance that they will pay the amount within 30 days. Government will not appeal against it. So that was a huge catch point. If the government appealed, that means a delay of 6-7 years. So this was a very, very unique model. And let me just show you a small video of a panel discussion in which I was there with the chairman of one of the conciliation committee of ports, which was set up just about 1.5 years back. So I'll just show you a small video on this.
Settlement committee. So we'd like to know your experience in this particular forum, what kind of cases are coming, how you are adjudicating those cases, and what is the future roadmap of this particular forum, sir? So over to you, sir.
Good afternoon, all of you. Samrat, thanks a lot for starting this session with me. This whole concept of, as you rightly said, dispute resolution, alternate dispute resolution, it's not a new thing. But in spite of all these things, if you see, World Bank was doing ranking on various ease of doing parameters for India. And on this parameter, that is dispute resolution, commercial dispute resolution, India's ranking consistently was the worst amongst the last, I would say, 5 percentile, 134, 135, 130, never improved. We improved on all parameters which we thought were very difficult, transfer of property, custom clearance, dwell time, all kind of parameters. If we see getting a company registered, tax payment, everything, we improved everything, but we never improved on the dispute resolution mechanism. And partly you only mentioned, partly the reason is the large number of cases which are pending in courts, and more importantly, lack of expertise in dealing with commercial matters. Commercial matters require very different kind of expertise, which probably the legal system is not having. They are more tuned to criminal law, even civil law, but they're not tuned to commercial aspects of problems. Commercial aspects are very different in when disputes arise. So that is one of the reason. And you rightly said the way forward was thought to be arbitration. It was also thought to be conciliation. But conciliation actually never very strongly came up in the country, because there was no mechanism mentioned in the Conciliation and Arbitration Act. Who will appoint conciliators? How will they do? Only Chapter 3 does deal with the whole issue, but not in detail. Plus, how they will get appointed is never, it was not very much clarified. I would say the lead role in this sector, and Rajiv will, I'm sure, will delve on it when he is asked to speak. I think so. Some lead, as far as I know, was taken by even the public sector undertakings had something called a dispute resolution board, which is a similar mechanism as a CSC. But at the ministry level, I would say Road and Highways took a lead. They created something called a conciliation committee, and they started taking cases. Taking lead from that, success story, the Ministry of Port, Shipping and Waterways now started a similar thing with experts, and then it was felt that even experts were, since we were not, didn't have fixed experts, we had left the expert panel to the ports, and therefore that model was also not succeeding, because you have to have a panel, a shortened panel. There should not be shopping of, judges also, If we have a very large panel, then people do shop, they talk to experts. So this is a unique way in which ministry created a mechanism of this alternate dispute. And I'll quickly tell you, it's a extremely, not because I chair it for the major ports, but actually there isn't a mechanism of this kind anywhere in the government or public sector. And now I will just say 3-4 things which will really bring out the uniqueness of this whole exercise. First, it's absolutely time-bound, 6 months. If the CSC is able to resolve a dispute in 6 months, fine. Otherwise, it closes, period. It's not allowed to extend. At best, further limit of with both the parties, consent of both the parties, further 3 months is allowed, otherwise no extension. There's nothing like, nothing like giving extensions. Even arbiters take 5 years, courts take 10 years, 12 years.
Oh, I think it stopped.
How much we all know. So it's a time bound first. Yes, sir. So therefore, it created that impact, that urgency, that everything has to be time bound. Now, what is the result? It is not at all process-oriented. All our legal systems are highly process-oriented. Someone will write a huge petition, written comments, you send to the other party, he writes 500 pages, again it's written, zero paperwork, no paperwork. As a matter of policy, whatever cases we have done, no paperwork. We just take verbal, we do ask for documents, but we don't ask for any long written submissions. The committee usually has to understand the subject and then write down a clear settlement agreement. Simple. So it's not a process oriented. If it was process oriented, it wouldn't get finished in 6 months. So no processes. I mean, we don't allow any kind of evidence taking, you know. Parties will submit documents, you see the documents, make out what's the problem, and then try to resolve the problem. Second. Third, and very important, it's a success fee model. If parties reach settlement, the conciliators get paid. If there's no settlement, they don't get paid. Simple. Unlike award, arbitration, judge. In arbitration, the first thing is, the arbitrator's first thing they'll say is, I'll charge 10 lakhs per sitting. And then they have 100 sittings, you know. Here, no per day sitting. You reach award, you get money. You settle, both the parties settle, you are paid. If they are unable to settle, and it happens, after 2 months, party says, no, sorry, we can't reach in settlement. Good enough, fine. You walk out. You can engage in other forums, success fee based. So the interest is, it's a success fee based, so interest is to resolve, try to resolve, you know, not to linger on and then try to, you know, make it as a business on a per day sitting basis. Fourth, the award is linked to the settled amount. Even the act, arbitration act, the arbitrators charge on the disputed amount. So if I have a dispute of 1,000 crores, they get charged for 1,000 crores. We have purposely, when we designed this whole guidelines, we said no. If 1,000 crores leads to final settlement of 1 crore, the fee is on 1 crore. It's not on 1,000 crores. So there are so many innovative things that we brought in, which are not there in any committee. Any forum will not have these kind of things. I can challenge. If any other forum in the country has these kind of, this kind of innovative ideas, you know. And because of this innovative ideas, what is happening is that there is a huge amount of interest in the committee. Even just, we are just 7 months, 6 months, old, started in October. Already, I think, so close to 25 cases we have, which is a large amount. Cases which are pending since 2003, High Court cases, arbitration awards since 2012, which have come to us. Out of 24, I can say, excepting 2 cases, 22 cases have been practically solved. 5-6 cases have gone to the boards. Rest all 5 cases are in the process of going to the various boards of port authorities. So it's a tremendous exercise. I can say it's a very rich experience for, personally for all 3 members of us. We are and very important again thing, we have given no scope of any shopping of arbitrators or judges. There are 3 members, no private person or a port has got any discretion in choosing. Unlike arbiter panels or high courts have, they pick and choose, they select. Even Sarod mechanism that we have 50 arbitrators, you can just choose anyone. Similarly for NHI, 100 arbitrators. So we give chance to the parties to pick and choose. All you can say is that, that all is over. 3 members that the government has, not government, I would say IPS takes 3 members, and that's about it. So there are no chance of any it's going out of these 3 members, and therefore no amount of outside intervention takes place. No one phones you. I'm told for no offenses meant, Mr. Lochan, but I'm told, arbitrators told me that people have contacted us. If you don't agree, they will go to someone else. Here, there is no scope of going to anyone else, only 3 members. So it's a very unique model, going very well. A lot of cases are coming. In fact, now we have so many cases that earlier we used to take 2-3 months. Now we are taking slightly longer because there are a large number of cases. And here, Mehra Amal is a witness. We had 5 cases. In fact, I would say 7 cases, including 2 closures. Out of the 7 cases, 5 are solved. Only 1 closure and 1 another shipping case is left. In the flat, I think so 3-4 months. Cases which were pending since, how many? Maybe 15 years, 20 years. 20 years. So very quick mechanism, very non-process oriented, result oriented process. And I think so the way forward for all such alternate does not mean I create an alternate which is worse or even, similar to the one already existing, There's no meaning to that. When you say alternate, it has to be a real alternate. It has to really break path from what is happening in the normal course of business. Until unless you do that. So
Settlement committee.
Right. So this is a reasonably successful model as far as public sector is concerned. And I think most other ministries are going to copy this model. What this needs, of course, is that your conciliation committee must have people who are extremely competent and of impeccable integrity, who are not subject to any kind of outside interference. Now, similarly, another scheme which is announced recently by Indian government is called Vivad se Vishwas. That means from argument to trust scheme. So this again entails something like this, that if there is a court order of a lower court passed and the contractor agrees to 80% of the amount, the public sector, the government will not appeal against it and he'll get it within a month. If he doesn't get it within a month, he'll be paid interest. Similarly, if an arbitral award is passed and the contractor agrees to 60% of the amount, the public sector or the government or the PSU will not appeal against it and he will get it within a month. There was also a proposal of ongoing litigation, but that didn't find in the final scheme which came out, that if there's an ongoing litigation and the contractor agrees to 30%, all litigation will be withdrawn. And similarly, if there's an ongoing arbitration or something and contractor agrees to 20% of claim amount, all claims, everything will be withdrawn. That didn't find in the final thing. So this is one scheme. The whole aim is that the contractors have a problem that they do get their claims, but maybe after 7 to 8 years, by which time many companies have gone bankrupt. And the net result is that the public sector or the government lands up losing more, but it's just a deferment of the pain by 7, 8 years. So especially small and medium contractors had a huge problem in this. There's also protection to small and medium contractors through the SMSE Act laid down. So there was some protection given to them in having fast-track dispute resolution mechanism. So this scheme is going on. It's been reasonably successful because everybody feels that even if I get a lesser amount, but if I get it right now within a month, that's better than hoping for, let's say, 20% more amount. Now a new mediation act has just come about in 2020, just now. It's just been enacted on 15 September, and which is going to give impetus to mediation, not conciliation, mediation. So pure mediation. Now it says pre-litigation mediation with consent, and post-litigation, you need not have consent. The court can simply direct the parties to go in for mediation if there exists any scope of settlement. The government wanted to again put an act where pre-litigation mediation would be compulsory. But we do not have in India adequate number of trained mediators and mediation institutes. So that is why there is a huge training going on. Institutes are coming up. And maybe after 5-10 years, probably even pre-litigation mediation may become compulsory through an amendment. But right now it is optional. During post-litigation, the judge may order mediation anytime. He doesn't need consent of any of the parties. So let's see, since this thing, and it's of course time-bound, 120 days, maximum more 60 days allowed. Not bound for any civil code, by any code of civil procedure, not bound by any evidence act and so on. And again, very limited grounds of challenge. So let's see how it comes about, because it's a very recently enacted act on 15 September. It's of course definitely going to be very successful for small level disputes, for family disputes, for other things. But let's see how effective it is in construction disputes. We'll come to know in maybe 2-3 years. So the major thing that's lacking in India, arbitral awards getting challenged, of course, is the one thing. But one of the major DRM that is totally lacking in India and is not there is a interim binding fast DRM, dispute resolution mechanism, during the currency of the contract. Something akin to a FIDIC DAB. So a FIDIC DAB, for example, now 2017, gives the power of suspension to the contractor if the DAB decision is not implemented and the contractor and NOD has not been given in time. So it's a interim binding. Similarly, statutory adjudication of UK, Australia, New Zealand, enacted by the SOP law, or Singapore, enacted by construction law, is again an interim binding. So that's called, pay now, argue later in UK, I suppose. That's what I've heard they call it in UK, pay now, argue later. So we don't have any kind of a DRM mechanism in India which is interim binding during the currency of the contract. During currency of the contract, all DRMs are something akin to mediation, voluntary. So they have generally not been successful. So we all know all these acts. So in all these countries, you have the interim binding dispute adjudication through a law. That this law, India does not have a construction law. We don't have a Security of Payment Act or a construction law or a construction contract act on the lines of HGCRA of UK. There is no such law in India. I'll just cover in next 5 minutes a bit about dispute avoidance and what steps are being taken in India, and then we'll just have a little discussion. I can see some questions, sorry. So in dispute avoidance, firstly, let me just clarify, we have an Indian Contract Act of as far back as 1872, which basically, in a way, you can say, put in the act everything that is there in the common law of UK, common law, construction law, of contract law of UK. But for those participants who are from civil law countries, this is not a civil code, because India is a proper common law country. So this is like any other statute which has to be interpreted by the judges. So one provision, for example, one particular clause says consequential loss not admissible. FIDIC also says consequential loss not admissible. But then it is the court or the judge or the arbitrator who has to decide what is the consequential loss based on the principle of Hadley versus Baxendale and other judgments, whatever have happened. So that's how this is a pure statute, not a civil code, because India is not a civil law country. But we do have a contract act, which incidentally UK itself does not have. So in dispute avoidance, there are three things that we do. Firstly, selection of tendering procedure, selection, where you have the most economical advantageous tenderer. You try and have an equitable contract, and you have a good contract management. And then, of course, you have DAAB, Dispute Avoidance and Adjudication Board, which FIDIC is now turned to. So in India, generally, all these three are a bit lacking. So till now, we have, including private sector, we generally have L1 tendering. PQC, pre-qualification criteria, L1 tendering. In 2020, for the first time, selection of contractor based on quality cum cost-based method was permitted in government sector, but with the proviso that quality parameters will only be 30%, cost will be 70%. So in that sense, we do not have a most economical advantageous tender methodology or a best value analysis that is happening in Europe and many other places. Similarly, there is no mechanism of rejecting a abnormally low bid tender, the World Bank norms, etc. So in India, what we do is when there's an abnormally low bid tender, you generally call the person for explanation, or you ask him to give a little more performance guarantee to check his credibility and as a security to you as an employer if the project fails. That's all you can do. No mechanism to prevent front-end loading or do something like price balancing, which is mandatory for public contracts in Kuwait, for example, Kuwait price balance, public tender law of 2016. Similarly, in making a contract balanced, these are 4 or 5 methodologies which are used all over the world. Now, again, in India, we have not yet graduated to what is shown in yellow. Early contractor involvement, alliance contracting, integrated project delivery. Autodesk did a beautiful integrated project delivery for their new headquarters in Massachusetts. Collaborative contracting and so on. So we are still on the upper sphere, which is basically the traditional contracts. Remeasurable and EPC, primarily mostly based on FIDIC Silver Book, and a little bit of EPCM. So we have not yet graduated here in India on the lower spectrum, which is basically partnership contracting. Let me just quickly run through this. So in India, this is a big problem that we have a plethora of bespoke contracts, plethora. Although slowly industry is graduating to FIDIC for bigger contracts, but they are very, very badly changed to the extent that I would say it does not comply with golden principles. However, situation has considerably improved in the last 4 or 5 years, primarily because people have realized what disputes are costing. Agencies have realized that disputes are costing quite a bit. So just to give you an example, in remeasurable contract, these are some of the differences between FIDIC and Indian. So delayed issue of drawing may lead to only entitlement of EOT and no additional cost. No time frame for determination of claim by the engineers. No time limit for, let's say, variation, valuation of variation. Similarly, you may have right of suspension. This is one thing that's missing in all Indian contracts, private, public, all. The contractor has no right to suspend the contract for any reason whatsoever. This is only the employer has the right to suspend. The contractor may have the right to terminate for a delayed payment beyond, say, 4 or 5 months in some contracts, but no right to suspend. So these are some of the things which are not really equitable, I would say. And slowly they are changing because of the huge amount of disputes that are coming. Similarly, Indian contracts do not have any time bars the way FIDEC has 28-day time bar. If you don't give a notice in 28 days, you have no entitlement to a claim. And now in 2017, 84 days claim. If you delay, you have no entitlement to a claim. So time bars are not there in Indian contracts. And in fact, I would go a little further and say that time bars are void in Indian contract as per the Contract Act. So let me just take 2 minutes since I don't want to overshoot time and show you the minus and plus of Indian contracts in terms of dispute avoidance. I'll not go into too much of this. The minus points is that we do not have a construction law and SOP Act or any unfair contract terms acts, etc., which will make the contract equitable. So I can make the contract as inequitable as I want to, and it is not illegal. I can have payment terms for each IPC as 150 days. It's not illegal. I can say no additional cost for delayed possession of site. It's not illegal. So that's a little bit of problem. No suspension rights of contractor for whatsoever. No entitlement to loss of profit. So to get loss of profit, contractor has to go into arbitration or a legal case. And no timelines, as I said, no time bars. There are plethora of contracts, no standard form. There is no interim binding fast dispute resolution. There are some time bar clauses which have now crept up, copying FIDEC in Indian contracts. But as of now, these have been given by courts as void. So we have a Indian section, Contract Act Section 28, which says that any agreement that prevents or restricts a party from seeking remedy in the case of a contract is null and void. So this currently is being interpreted by the courts in India to say that pure refusal of a claim due to time bar is void. You cannot refuse a claim just because it is time bar. And culturally also, I can tell you, India does not have a culture of refusing a claim purely because of time bar. That is very, very rare. Culturally in India, claims are refused only because of merits or because of various other reasons, but not because of time bar. So only time bar that will apply to claim is the law of limitation, which in India is 3 years. So good parts of Indian contract, firstly, payment terms. Our public sector contracts have some of the best payment terms in the world. So payment terms is that if you give your interim payment, if you give your invoices within 10 days, just by a broad checking of your invoices, you will get 90% of your payment, 75 to 90%, depending on certain departments give 75, some give 90. And within 28 days, you'll get full 100% payment. In contrast, FIDEC is 56 days, right? And if you actually see this cash flow, for example, if you follow FIDEC contract conditions of 56 days, and you see the tendency of employers to generally give payment on the last few days only, you will find a construction project generally having a negative cash flow for almost the entire period till the retention money is given. So Indian contract payment terms, many public sector and especially all central government, federal government contracts have this wonderful payment terms of 90% payment or 75% payment within 10 days and the remaining 25 or 10% within 28 days. Similarly, we don't have time bar. This may be a good part, may be a bad thing. Bad thing because it postpones disputes for a later period. Good thing because it is more akin to unjust enrichment, good faith, etc. That a very valid claim of a contractor is not refused only because of a time bar. So maybe good, maybe bad. We have provisions in Indian contract that EOT can be given even if application is not made by the contractor. So very good for smaller level contractor who often do not have the wherewithal to do good contract management. Almost all contracts in India, especially of central government, have a price escalation clause based on inflation. So there are no pure fixed price contracts in India. Some PSUs have them, but they are rare. All contracts, even EPC fixed price contract, will have a price escalation mechanism based on government published indices. So in an EPC contract, you will broadly lay down that this particular project constitutes, say, 30% cost of the project is cement, 20% is steel, 30% is labor, 20% is so-and-so item. And then price escalation is applicable on all the items on a quarterly basis based on published index. So there is no pure fixed price contract, which is very good. This does not cater for too much of market fluctuations because within the quarter also you may have, but still it's far better than having a pure fixed price contract. So in many PPP contracts, you have a sharing of cost of the engineer between the employer and the contractor 50-50. So that leads to a little better impartiality of the engineer. Similarly, in many Indian contracts, we have payment of additional cost based on thumb rule. So for example, in acceleration clause, which one of the contract which I framed, we said, okay, acceleration will be so much and contractor will be paid 0.25% of the balance value of the contract which is accelerating per week, 0.25% per week. No need for any substantiation. So often head office overheads are given purely based on a H-lay formula or MDEN or Hudson formula. No need for substantiation. So the burden of proof on a contractor many a times is much less. Concurrent delay, now many agencies are including concurrent delay in their general construction, general conditions. Mostly Malmaison approach, Malmaison versus Henry Boots, that is contractor entitled to EOT and no additional costs. So these are some of the things that are there in India. As a final summary, I would say this is one thing which is very, very badly lacking when it comes to dispute avoidance. So an SOP Act or various other things, that is lacking. And we have a situation improving quite a bit, but these are the three major voids that are there in India. We don't have an interim binding fast dispute resolution mechanism. We don't have a construction law like a GCRA, which makes the contract somewhat equitable, at least in payment terms. And we need a huge capacity building in construction contracts. We don't have institutes which specialize in construction contracts. We don't have law universities which specialize in construction contracts. So these are certain things that are lacking, but situation is improving quite a bit and people are realizing. So in the last 5 years only, I've seen a sea change in what used to happen, say, 20 years before. So we'll finish off with this because I don't want to overshoot. And let me just see 3 questions and then we can have any other questions also which will come.
From Sar, who says, from the presentation, it is clear that in most cases, the ruling of arbitrators are challenged in courts. What can be put in place to ensure that the decisions of an arbitration board are respected?
That's a big problem. So what courts are doing now is, frankly, in almost 80% cases, the decision of arbitrator is not changed. The courts uphold those decisions. But unfortunately, that challenge ensures that the payment is delayed by 7 years, 6 years, 5 years because our courts are clogged. So this is something that has not really been worked out. There's a problem in domestic arbitration. In international arbitration, of course, you can take the seat of arbitration as Singapore and you'll have no problem. You can even take substantive law as Singapore. So that's this thing. But yes, you're right. This is something that perhaps need maybe enactment of a law. It needs something, and it needs a behavioral change because, frankly, in India, the biggest litigant is government. So if you see the famous report of Sir Michael Latham in UK also, one of the sea change that happened in Britain was that the government committed itself to becoming a model client. And perhaps, let's see, I mean, it needs a cultural change, it needs a bureaucracy change, it needs something more than what I can think of. It needs a C-level change to ensure that arbitration judgments are not challenged in court. The plus point is that most of the times they are not interfered by the court. The court upholds these arbitration judgments. So why people challenge is frankly only a delaying tactics.
All right. Yeah, thank you. Okay, the next question is not actually a question. This was during the video that you played, the clip. the person asked for the link to that video. So if you could email me the
I'll give
link.
you. It's there on YouTube. The full video is also there on YouTube. I'll give you a link.
Okay.
In fact, I've shown you only the extract of the video. I'll show the full video is also there on YouTube. So I'll give you the link for that.
Okay, thank you very much. And I will include that in the informational email that I send. Okay, next question. Val says, are the payment terms of 10 or 28 days applicable to public projects exclusively? Is there legislation regulating this? And is this applicable regardless of a contract option used? Also, the second question, how do DRB members, how does the DRB member appointment process, how can it be improved, as it can be extremely powerful? And what are other challenges with this DR option in India? So there's a few questions in there.
Right, great, yeah. So I'll just come to the first one, Val. Right. So 10, 20 days exclusively only for public sectors and not a regulation. And let me tell you, this is not a regulation or a regulation of the government of India. It is something that government sectors and public sector agencies have voluntarily adopted. It's not a regulation. There is no mandate to put 10, 28 days. There are some autonomous public sector units which are putting more than this. But by and large, everybody is putting 10 days, 90% or 75% minimum and 28 days, exclusively public sector. In fact, I would say today, this is one thing in my payment delay survey, I found that the responses which came from 2,000 respondents, the central government, federal government contracts were the best in payment, timely payment, followed by private sector, and then followed by municipal corporations and so on. So the federal government was regarded as better in payment, even than much more than private sector. But yes, this is not a legislation. It's something that public sector has voluntarily adopted. There is no regulation. As I told you, in private sector, I can have a payment term of 120 days. And I've been guilty of that when I was working for a private developer who was facing losses. Second thing is, how can DRB appointment process be improved? I think the only way out is to have extremely good institutional DRB, just like we move towards institutional arbitration. So you need to have institutional DRB. Today, we have a huge lack of capacity in India in finding good members. Even recently, our Supreme Court Chief Justice said, he's not able to find good judiciary for high courts. So we have a huge capacity problem. So I would say the only way out is institutional DRB. We are moving towards institutional arbitration. We are moving towards institutional mediation. But I suppose that's the only way. But it needs a huge something at the apex level. So huge capacity development, issue of having impartial and competent DABs and DRBs, because the general tendency, frankly, is to employ retired officials of public sector who don't really inspire too much of confidence. So that's a policy thing which will have to be looked at the highest level. Are there any certifications or diplomas which treat dispute? Yeah, there are many certifications. You have ADR in India, but not exclusively for construction. So you can do an LLM in ADR, you can do anything, but that's not exclusively for construction.
Okay. Yeah, that it's such a narrow field. I think it's difficult to find a degree that's so specific. Yeah.
So let's, I'll just, okay, I think, are we running short of?
Okay, the next question is from Aaron. Not many people highlight the goods of Indian contracts, and you have highlighted them, which is encouraging. However, you mentioned that ICA 1872 does not facilitate for time bars for claims. Most of our public contracts, especially JICA, WB, ADB, funded, are based on FIDIC, wherein there is a time bar. But if any contract is bound by ICA 1872, then it is the T&C of FIDIC in a way null and void.
Yes, current situation is like that, unless you get a Supreme Court decision which goes to the contrary. Now, the two cases which are precedence cases which I showed you were both unique in the sense that both cases dealt with instructed variations. and where the amount of variation was not disputed. The variation, you would be knowing, of course, that FIDIC does not have a time bar for variations now in 2017. There's no time bar for variations. So they are not really, I would say, precedent cases, but as of now, unless a new case comes up and some other decision is given by our higher court, yes, the time bars of FIDIC are null and void in India. So if you try and uh, for some refuse the claim purely based because the person instead of 28 days has given a notice in 60 days, you may get a decision from arbitrator and the court against it. It is null and void. Yes. So this FIDIC clause is not applicable in India as of now. Yes.
All right, that's good information. Okay, the next question is anonymous. How can you practice arbitration in India?
That's a little longish one, so I'll request the. I think that's not really pertaining. Many ways you can do. You can become a lawyer and various things. Of course, arbitration is generally dominated by lawyers. So many ways, but I do arbitration. I'm an engineer. I'm not a lawyer. All right, so that's that I'll skip it because that's a little different type of a question.
Yeah. Okay. Yeah, there was another question about what courses are available in India related to construction contracts and law and dispute resolution.
Yeah, unfortunately, in India, as far as construction, you don't have any course on construction law. The way you have a 3-year LLM or a MSc in UK, Leeds or Robert Gordon or King's College, you don't have in India at all. So there are no big, or the way I am doing LLM, for example, in Pantheon University, along with Valerie and some participants who are there, there is no course like that in India. So you only have certificate courses in India on construction law. You don't have any degree, you don't have any diploma course also on construction law. That's a little problem on construction law or specific on construction arbitration also for that matter.
Is that something that you think is going to change, or is that?
Yeah, I think it will change because now institutes have started giving certificate courses on construction law. People are looking at it. So I think in a couple of years it will change. It will change.
Okay, good. All right, next question from Udit. Thank you for the informative session. In your experience, what is the acceptability of overheads calculations formulas like Eichler, Emden, etc.? And if you were to answer in terms of ratio or percentage, that would be helpful.
I would say based on my experience, 80%. In 80% cases, the courts or arbitrator have not asked for too much of proof, especially if it's a HLA formula or Emden, because as we know, Hudson is more of a theoretical formula where you don't have to give company overheads and company account sheet. But in HLA, you have to give your company turnover and company overheads and audited statement. So 80%. But correct practice, of course, is that these formulas are only for substantiation. You have to give proof. But in India, as I said, the burden of proof is easier. So if you use something like HLA and Emden formula, then you may not have too much of burden of proof.
Gulam asks, it's good to see one institution started impartial and time-bound ADR based upon settlement. Why isn't this model launched under a big umbrella to save public money with standard forms of contract documents published by the Engineering Council or included in formal ADR systems of FIDIC?
So I suppose you are talking of the institution of CSC, Conciliation and Settlement Committee, whose video I showed you. Yeah, that is now starting. 3 ministries have already adopted it. It's been very hugely successful. And I suppose it will come about in entire government of India. It will slowly come about, maybe in next 2-3 years or 5 years. Entire public sector contracts, this will happen. In private sector, there's a little problem in the sense that in India, you will find pure private contracts are generally settled by negotiation or at best mediation only. There is very few even arbitration because it's more of relationship based. The problem is more in public sector contracts always. So yes, this is coming about, and probably this conciliation and settlement committees will spread over to all public sector contracts in India.
Thank you. And Salman asks, in India, is the LLM or MSc in construction law and arbitration from Robert Gordon University recognized?
Yes, it will definitely recognized in the sense for a law practice. Yes, but for law practice, you need an LLB from India. You need that. So all countries want a JD or an LLB. In terms of other things, yes, very much. We do have a lot of law professors who are LLB from Robert Gordon and King's College and Leeds.
Okay, so basically they just need the one qualification from India, and then that would be an additional qualification.
I think that's the case in all countries. Nobody in US also, if you go without a JD, you can't practice law. You
Yeah,
can do an LLM, but you can't practice law without doing a JD.
exactly. Okay, Sushil asks, what are the measures taken across PSUs in India for settling COVID-19 claims?
Similar to all over what happened in the world. So I can tell you, Indian government was far more liberal than many other governments. It took COVID, it announced COVID-19 as force majeure, and it gave a blanket sanction of 6 months EOT on all contracts, irrespective of the fact whether the contractor was going slow, whether he had got a final notice for termination, anything. Almost a blanket 6 months EOT was given. And you would know that claiming additional cost for COVID is a struggle for contractors all over the world. Entitlement of COVID, even as per FIDIC, purely is EOT. And even if you see the guidance note of FIDIC, it tells you negotiate. We have no contractual solution. Contractual FIDIC entitlement of COVID is also only EOT and no additional cost.
Okay, Afzal asks, firstly, thanks for sharing your knowledge with us. And the question is, why is the majority of the public sector projects delayed compared to the private sector, even
So
with the
I mean,
best
that's a
payment
fallacy.
terms?
That's a very big fallacy. If you think that public sector projects are more delayed. No, private. I've worked 5 years in corporate and I've done subcontracting. Private sector projects are equally delayed. I was establishing a factory in Hyderabad. It was delayed by 3 years. So that's a pure private sector project. So private sector projects are equally delayed in India, probably even more. Public sector projects come into limelight because they are big budget projects. The big budget projects are all public sectors. So that's why they come into highlight. But otherwise, let me tell you, with my experience in corporate and public sector projects are equally, if not more, delayed. Say, for example, you take real estate projects in India. How many real estate projects are delayed? Almost 99%. So therefore, it's a fallacy if you think that public sector projects are more delayed. Private sector are equally delayed.
Next question, Aaron says, sir, you highlighted on contracts on partnerships wherein the contractor is on board in the early stages. Is that actually possible in Indian government contracts, as there is a competition commission that may be a constraint?
No, competition commission has got nothing to do with it. After all, UK is doing it very successfully. Entire Highway England is on early contractor involvement, and HS2 is early contractor involvement. So it can be done, but it needs a different mindset and thinking. So that will take time. You need to have people, audit people on board. You need to have vigilance people on board. They need to have interdisciplinary knowledge of understanding these things. So it is very much possible, but you need a huge amount of capacity building on this.
All right, next question is another anonymous one. Which mode of ADR is best for working in low budget projects? And is there anything functioning like an amicable settlement?
Obviously, negotiation is best, but I always tell private sector low budget, and I'm advising many of the low budgeted small private sector people, and I always tell them don't go beyond mediation. And even if your contract does not have mediation, nothing prevents you from going in for mediation with the consent of both parties. So as far as low budget project is concerned, I would say don't go beyond mediation.
All right, the next question is about arbitration and how do parties in India obey arbitration?
I think we covered that with Val's question that yes, there is a problem of appeal against arbitration award, but you can be rest assured that in 80 to 90% cases, courts will not change the decision. The appeal is generally done by bigger parties simply as a pressure tactic to delay giving the money. That's it.
Okay, another anonymous question. Could you elaborate on change order limits via work order amounts for public sector contracts?
Okay, so every, it's a standard ruling. So for example, most public sector contracts have a variation limit of 10%. But beyond 10%, you can go with a special sanction. So generally, broadly, In a lump sum contract, the change order limit is 10%. And in a item rate, unit rate contract, remeasurable contract, you can change the quantity of item up to 25%. FIDIC gives you a limit of 10%. Indian contracts give you a limit of 25% at the BOQ rate approved in the contract. But change limit mostly is 10% in Indian contracts. Beyond that, you have to take special sanction in public sector contracts.
Next question. Sushil asks, does awarding EOT necessarily mean payment of prolongation?
You'll have to join my workshop, Sushil. Please join my next workshop.
Okay.
Or maybe the next ICCP workshop.
Yes. We have recently done 2 workshops on prolongation costs. So if you do go to our YouTube channel, earlier in the summer, we had 2 sessions on prolongation costs. Hopefully those will answer your questions. Okay, and next one, Anonymous asks, how do you avoid the arbitrariness of quality components weightage in QCBS mode of tendering?
So in a best value analysis or a quality cum cost base, you may have some subjectivity in the Q factor. That is avoided. What I do is, or what I used to do when I was in public sector also, is best way to do it is have an interdisciplinary committee of 4 or 5 people to have this kind of formulation of Q factor. So for example, when I was making the Q for smart cities in India, consultancy contract, we had a chairman who was the principal secretary of Public Works Department. Then we had the finance secretary, we had the law secretary, we had the dean of the engineering college. I was the member as a chief engineer. We had the municipal secretary as chief engineer. Now, when you have a committee of these 6 diverse people, you will get the right answer because, the arbitrariness or the subjectivity or the bias will be automatically avoided. So have an interdisciplinary committee constituting of experts who are well-versed with infrastructure projects.
Sushil asks another question. What is the effective method of delay analysis and calculating the effective delay on key
He'll either
dates?
have to, again, Sushil, have to join my workshop or an ICCP workshop for this.
All right. And I will say also, we do have quite a few videos on delay analysis on our YouTube channel, and the slides can be found on the webinar page of our website. Delay analysis is always a hot topic.
Thank you, Jennifer, and thanks
Thank you,
to ICCP
and thank you
also.
everyone for attending.